Hello, and welcome to Shook, Hardy & Bacon's Quick Hits webinar series. In this webinar, Victor Schwartz, co-chair of Shook's public policy practice, will talk about one of the key issues affecting business, the alliance between the trial lawyer and the state attorney general. We want you to be part of this webinar. If you have any questions, feel free to type them in the Q&A window on your screen, and they'll go directly to Victor's inbox. Or you can always contact Victor directly through the speaker window. With that, let's go ahead and turn it over to Victor.
Hi. Today I'm going to talk about what is one of the most major concerns of business, and that's the new fuel for the trial lawyer state attorney general official alliance. A combination of power that is very difficult to deal with. It's one thing to deal with trial lawyers alone, and another thing to deal with attorney generals and officials alone. But when they get together, overkill is possible. In this talk, I'm going to also provide some remedies as to how to prevent this type of overkill. Plaintiff lawyer leadership is really trying to use this new fuel now to foster their alliance with state attorney generals. Under President Bush II, an executive order was issued that says to every agency that they may not hire lawyers on a contingency fee basis. We actually worked on that project. And the reason for it is that contingency fee lawyers, who are very good and important parts of our society, their goal is to make as much money as possible. There's nothing wrong with that. But the government's role in litigation may not be that. It may be to curb an activity. It may be to have an injunction. It may not be to have the most money possible. For that reason, President Bush signed that executive order. That is still in place. It survived President Bush, President Obama, and now President Trump. So what are the trial lawyers doing to get around that problem? In laws before Congress that they are pushing, it is very, very quiet about it. They're putting provisions in the law that would empower state attorney generals to enforce federal law. Empower state attorney generals to enforce federal law. For example, there is a bill called the Allow States and Victims to Fight on Sex Trafficking Act. And in that law, not only would the state attorney generals, federal attorney generals enforce it, but so would the state ones. And the state lawyers, the state attorney generals, can hire contingency fee lawyers. So they get around the executive order. In fighting back on this, first, one has to find them. These are buried. And your government relations people need to see when these things are put in federal bills. Often they may be on page 250. Once they're found, arguments need to be made against it. And the fundamental argument is this, that by doing this, by empowering state attorney generals to enforce federal law, where the state attorneys generals can hire contingency fee lawyers, they are circumventing the very policy that was endorsed by Presidents Bush, Obama, and Trump. How many are the things like that, where all three presidents endorsed it? That fuel, though, is set and is going to be extant as long as the Democrats have a majority in the House of Representatives. And sometimes senators, Republican and Democrat, either advertently or inadvertently vote for these provisions. A second fuel that is going to foster more of the alliances between government officials and contingency fee lawyers are the recent elections of attorney generals. There has been a decade-long battle over the role of state attorney generals. One view is that a state attorney general should enforce civil and criminal law, that if a company has a bogus ad, is selling a bogus product, the attorney general should stop that That's his or her role. That has generally been the view of Republican attorney generals, with some exceptions. Among Democratic attorney generals, there's a slightly different view among a number of them, and the slight is very important. Not only do they see themselves as public officials enforcing laws to stop fraud, they see themselves also as surrogate plaintiffs' lawyers, seeking damages in tort-like cases. We are going to see more of these cases brought because there's been a very major shift in the number of attorney generals who are Democrat versus Republican. The slides show this. There's been just majors. And this will have an effect on everyone in states where there has been a change to Democratic attorney general. They are more inclined to work with plaintiffs' lawyers and take, in addition to their role, the role of acting as a super plaintiffs' lawyers. And I said in the beginning, it's one thing to have a plaintiff's lawyer come at your company. And if it's a good plaintiff's lawyer, it's no fun, and many of them are brilliant and good. It's a separate thing to have a state attorney general with all his or her power, their subpoena power, their governmental power, come at you. But when both come at you, that is very difficult to handle. And the result may be that the checkbook comes out. At least in my discussions with the plaintiffs' lawyers, they really don't want to litigate these cases. They just want to get a settlement from you. So that change in election and the change in who is the state attorney general is the second fuel. The third is a creative effort by plaintiffs' bar. And I'm not talking about all plaintiffs' lawyers. I'm talking about the major class action type lawyers, such as Motley Rice, to actually have part of their firm totally dedicated to working with public officials. For example, the Motley Rice calls that unit the public client practice, and their work is to build bridges with state attorney generals, visit with them, tell them ideas that could make them famous. You know, it's an old thing about the National Association of Attorney Generals. Some call it the National Aspiring Governors Association because they hope someday to have a higher office. I mean, President Clinton went from a state attorney general to be president of the United States. Yes, I did. I did that, and I was well rewarded. So by having big hits in civil justice, that gets fame, it gets publicity. There has been a change, and this is a new fuel. And this really was the thought of Motley Rice and in some of the very smart people at these firms that practice this type of effort of working with state attorney generals. There's been an effort by the business community to blunt these alliances and at the very least, create disclosure of the amount of fees, whether there's any relationship politically between the state attorney general and the plaintiff's lawyers. These disclosure laws are now law in a number of states. So the ability to just hire a plaintiff's lawyer by some attorney generals is limited. These laws are called the Private Attorney Retention Sunshine Laws. They have other laws with the same goal. So when the plaintiff's lawyer's firm is thinking about what's going on, a brilliant idea occurred. Why rely simply on 50 attorney generals? Let's expand the number. And what they are doing and thinking about, and it's happening, is to pitch their lawsuits not simply to state attorney generals, but to officials in cities, counties, and other public entities. Plaintiff's lawyer, who is being kind of humorous, said the business community is going to have a challenge. Instead of dealing with 50 gorillas, they're going to deal with 1,000 monkeys. Well, I don't think it's a very good thing to call public officials that kind of name. In fact, I disagree with it. But it does give their thinking in a very dramatic way. The state attorney general, plaintiff lawyers who have been involved in this area have been somewhat limited in number. Like Motley Rice, it's a specialty, or Weiss-Luxembourg, a specialty. But on the slides we'll tell you some of the names. More plaintiffs' lawyers are entering into this gravy train. They see this as a way to become multimillionaires, and it can be, and also to get public recognition. With the change from the 50 attorney generals to hundreds or potentially thousands of officials at lower levels, the business community has a real problem in front of it. Already lawsuits have been filed on climate change against major oil companies. The theory that the oil companies caused the climate in New York to change, or local areas in California. Now, all of us know that climate change has many factors. It isn't one company. It isn't one country. And proving causation is almost overwhelming, and some of these cases have been dismissed, but not all. And if the causation issue can be sort of just put in a cuisinant and forgotten, progress may be made. A plaintiff's attorney told me, Victor, we don't need 10 victories. All we need is 1 or 2, and the rewards will be outstanding. It is going to be very difficult to address this. It's not only climate change cases, but data breaches, financial services, and more. The business community and defense lawyers need to think about how to address this in a way that stops the trend before it becomes enlarged. It will become enlarged if light is not placed on it. I'm a firm believer that sunlight cures. If one, an ordinary citizen, understands that the official he elected has been compromised by farming out his work to a plaintiff's lawyer, sometimes citizens themselves can write the officials and say, we don't want you to do that. Here to curb this trend, which is just starting, but it's there on climate change, data breaches, is to, oddly enough, make friends with attorney generals on this issue. Some companies that I know are already doing that. Because when you have an attorney general of a state, take the opioid litigation, for example, where the attorney general wants to be in control of it, but he's got 50 cities, all with independent action, his or her ability to enforce the laws of the state are compromised. The litigation is all over the place, and the monies may end up not where they're used to help abate the crisis or deal with a victim of opioids and the tragedy involved, but coffers filled by counties and cities. So on this particular issue, the state attorney general can be your friend. The American Tort Reform Association and the Institute for Legal Reform are giving thought to modifying the Private Attorney General Retention Sunshine Act and a law called TPAC, which put sunlight on state attorney generals hiring outside counsel and expand them to also include cities and county officials, so that no in-the-dark, hidden from the public hiring of outside plaintiff lawyer counsel occurs. This is an effort that may help reduce this diaspora of enforcement of law. In conclusion, I would say this, that of the trends that are right now adversely affecting American business, the new fuel into the Plaintiff's Attorney Public Official Alliance is major. We are really just at the early beginning of this. If it's successful, we will see more. I thank you for your attention, and I hope you found this of interest.
And that concludes this Shook, Hardy & Bacon Quick Hits webinar. Please visit shb.com for more experienced insight on additional legal topics. Thank you, and have a great day.